All right, folks, it's time for our favorite podcast, Cut to the Chase. I am going to cut to the chase right now. I brought Matt Hosen back. Breaking news, we're cutting to the chase. 3M bankruptcy, is it all over? Judges are making rulings. Matt, I brought you on to educate the audience. Everybody's dying to know what is going on. So how are you doing today, first of all? And
we've had our first sunny day here in Pensacola in like 2 weeks, so I might head to the beach after this podcast.
all right, beautiful. I love it. And maybe that's a sign from above that the stars are aligning and our vets are going to get compensated. But let's go ahead and break this down. People were hearing there was a bankruptcy. How could a Fortune 500 company file for bankruptcy? Is this the end of the ball game? I've already had a couple of episodes saying no, we're going to fight, and so the fight has begun. And there's one big update. So let's take a step back. What happened, and
Sure.
Explain what this all means.
Sure. So how we got here is, as I'm sure all of your viewers know, 3M company, and as well as its subsidiary Aearo Technologies, along with a few other Aearo entities, they are all named defendants in the largest mass tort in history, this combat arms Earplug. So there are currently over, I believe, 230,000 current and former U.S. service members and veterans who are suing 3M on this defective earplug. Now, we've had 16 trials so far. We have won 10 of them and gotten verdicts for 13 individual U.S. veteran plaintiffs. And the total amount of those verdicts was about $300 million. And so obviously, 3M is in a bit of a tricky situation right now because it's still got hundreds of thousands of additional lawsuits that could potentially go forward. And it hasn't been willing to settle the cases. So what they did was they did something that other mass tort defendants have been doing in recent years. And that is they had their subsidiary, Aearo, along with various Aearo entities, they declared bankruptcy. 3M company did not declare Chapter 11 bankruptcy. It was their subsidiaries that declared bankruptcy. So during a Chapter 11 bankruptcy, one of the first thing that happens is you get what's called an automatic stay. So if Aearo, which is currently involved in the MDL, the proceedings against Aearo in the MDL were automatically stayed, meaning they were paused. Nothing can happen for Aearo in those proceedings. But Aearo wanted to take it a step further and say, look, not only does the matter need to be stayed against us, but it also has to be stayed against 3M company. Okay, so that was the purpose of what Aearo was trying to get in its bankruptcy. The purpose, 3M's purpose in having Aearo declare bankruptcy was to get the litigation, the mass tort litigation, stayed against 3M without 3M itself having to declare bankruptcy. So basically 3M would be getting the benefits of being in bankruptcy without actually declaring bankruptcy. Because as you can imagine, if 3M company tomorrow came out and declared bankruptcy, their stock price might take a little bit of a hit if that happened. 3M company does not want to declare bankruptcy because that will have all kinds of implications for them, such as not being able to issue their generous cash dividends that they issue every year to investors. So basically, in this past week, we were in the Southern District of Indiana, in the Indianapolis Bankruptcy Court before Judge Graham, and Aearo, the subsidiaries, they were seeking a preliminary injunction from Judge Graham to stay the mass tort litigation against 3M company. So that's where we were at last week. We had a team of lawyers, new bankruptcy attorneys that we brought on from many of very good law firms, including Quinn Emmanuel. And we had a 3-day trial where each side presented witnesses and we did opening and closing arguments. After that, we had some briefing that the judge wanted. And then just yesterday, Judge Graham issued his ruling denying Aearo's request for a preliminary injunction.
All right.
So that's where we are right now.
Okay, so let's, because people are hearing trials, 19 trials, 13 victories. Now you're telling us about bankruptcy, 3-day trial, motion for preliminary injunction. I just want to, some people are like going from 1 to N to, oh my God, we're done. We're not going to get compensated, to oh my God, the judge denied the motion. So now we're going to win. I think that we got to take it a little bit slowly to see how this is going to play out. All right. So Aearo files for bankruptcy. They ask for a stay. In other words, they want all the cases that are still in the hopper, the 229,900 and 84, whatever, to stop in the tracks. So everybody's hearing about these trials, but what people don't understand is that all these other cases, they're getting litigated like a normal case would. Discovery, depositions, people are giving statements, and all these other cases, not all of them, but lots of them, things are already scheduled, depositions and all that. And 3M decided, hey, we're just going to cancel this, even though the judge has essentially set forward a scheduling order that needs to be satisfied unless for real good cause. And they just said willy-nilly, nah, we're not going to do this. But that was the purpose of the motion for preliminary injunction, was to stop all those discovery and deposition on all the other cases from going forward. Do I got that right?
That is correct. And the tricky part of it was that because Aearo and 3M Company are named as two separate defendants in the mass tort cases. So Aearo already had the stay once it declared bankruptcy. This preliminary injunction was about extending that stay to a non-debtor, which was 3M Company.
So bankruptcy law, if you file for Chapter 11, your company files for Chapter 11, your company gets an automatic stay. There's no argument right out of the gate. Everything stops, all the other litigation stops, and then the bankruptcy proceedings take place. That doesn't mean that the bankruptcy petition will eventually get approved, but for the time being, that stops. So the litigation against Aearo stops, but the litigation against 3M continues.
Correct.
And Aearo was essentially just like a co-defendant with the 3M. So it doesn't really stop the underlying litigation.
Exactly. The fact that the mass tort litigation is stayed against Aearo has no real practical effect, because we've actually gotten a recent order from the judge in the mass tort litigation, Judge Casey Rogers, who has said that these Aearo subsidiaries they're only defendants in name only. 3M Company is the one that's controlling all the litigation on behalf of them. These are 100% owned subsidiaries. The hearing protection device business operations was fully upstreamed into 3M after the merger. So 3M is the one that is completely independently and solely liable for these claims. So the fact that these Aearo entities have a stay in place in the mass tort, it really doesn't help 3M at all at this point, because they lost this injunction.
All right. So, and it's a preliminary injunction. In other words, the court is basically being asked right out of the gate to make a preliminary final decision. It's not necessarily a final decision, but they're being asked to basically assess the merits of the case right out of the gate. And the judge denied it as applied to 3M.
That's correct.
All right. Now, is this a final order? Can this decision be appealed now, or do they have to wait until the end of the bankruptcy proceedings against Aearo?
So the judge said that he would make it a final order and that it would be able to be appealed. And I know in 3M Company just yesterday, they came out and said that they would be appealing it. But that will not stay. The fact that the fact that 3M has decided to appeal it, that order will not stay the proceedings against 3M in the mass tort MDL. Those will proceed as scheduled.
So, all right. So just taking a step back, Judge Rogers in Pensacola, she gets assigned the multi-district litigation with the 230,000 cases. She tries 16 of them. And then that was during the bellwether process, being that was basically designed to show all the parties, hey, we're going to try a bunch of cases, some good for the plaintiff, some not so good, some good for the defendant, some not so good for the defendant. We're going to see where it all plays out. And you guys at that point, you guys and gals should get a good idea where we're going, and let's settle these cases. So that phase had already ended. And then the Judge Rogers was essentially taking all the cases or lots of the cases and sending them back to the courts where they originated with those judges to take over those cases.
Yes.
So that is now, and that's like, what's that called? The wave?
Yeah, those are the wave cases. There were 3 waves of approximately 1,500 wave cases. Yeah.
So those have those been sent back to the original courts?
Well, so no, they haven't been sent back to the original courts yet, but we have gone through in most of the waves at this point. We've finished fact discovery. We've taken depositions, expert discovery, and so on. So those cases are all getting ready for trial. And now where those trials will take place is unclear at this point. Some of them will likely go back to the original jurisdiction where they were filed. Some of them will likely be tried here in Pensacola. Judge Rogers has indicated that she's willing to do more of these cases here, to try more of these cases since she's so familiar with it. So we'll see what happens there. But there is actually, my understanding is there's one trial that's already been set at this point, and that's in October of this year. So just in a couple months. I don't know if that trial is going to get postponed or continued. I'm not sure about that, but it just kind of shows that these wave cases are coming up and they will be set for trial pretty soon.
All right. So, I've got clients, you've got clients, we've got colleagues that have clients. Everybody's trying to figure out like what is going to be the thing that forces the issue in terms of settlement, getting these cases resolved. And from my perspective, the appeal in the 11th Circuit with the government contractor defense now is back. From my perspective, that is that's their big hope at this point. 3M. What's your take on their argument with the government contractor defense? Is it good? Is it tough? First of all, explain a little bit about it, what that means, and then give me your best take.
Sure. I'm biased, just so you know. Full
Yes.
disclosure. Okay, so the government contractor defense, it's a federal common law defense, and basically it came from this case called Boyle that was decided, I believe, in the 70s or 80s. And it's the purpose of the defense is basically it's for government contractors who are selling products or services to the government. And the defense is basically if it comes out that there's a problem, like a defect in a product that was sold to the government contractor can go, well, even if there is a problem, the government made me design it this way. The government made me do it. And so therefore you can't hold me liable because I was just doing what the government asked. Okay. So that is what 3M, as you said, that's basically their main argument in this case. And it's it's currently under appeal in the 11th Circuit. Now there are various factors and prongs that are used. But really, based on my research into the issue, and working with the attorneys handling the appeal and everything, I think it's a very weak appeal. The government contractor defense is not really applicable here for a few different reasons. Number one, when the government tells a contractor, hey, we want a product designed like this, XYZ, they have a specification where it's like a written specification. They give it to them and they say, look, it's got to be by this dimensions. It's got to be made out of this material. That's how government specifications work. There was no government specification for this combat arms version 2 earplug. This was Aearo at the time, and it became 3M. This was their plug, and they are the ones who profited off of it, and they're the ones who are responsible for it. A lot of these government contractor cases have to do with very complex pieces of machinery, missiles, helicopters, ambulances, maybe. Something like an earplug, there's never been a government contractor case where it's like they've said, well, the government made us design the earplug like this. Now, the only thing that 3M can point to is that over time, while this earplug was being developed, a doctor in the U.S. military who was responsible for hearing protection, he would ask 3M, hey, here's kind of what we're looking for in this earplug. Can you make it? Is that doable? Now, then 3M came back and said, well, yes, it is. Yeah, we'll do it. No problem. So that was it. So it was like, they're basically taking a request from the military and trying to spin it into like, oh, we had to design it like this. There was no contract between Aearo and the military, like a development contract, which is another thing that you often see, where, if the government said, hey, we're going to partner with you and we're going to develop this product, that did not exist with the combat arms version 2. All of that, plus the fact that 11th Circuit law is very favorable for us in regards to the government contractor defense. There are a lot of really good cases that we think we fall under. So I don't think it's very likely that they will succeed on the appeal. But as I said, I am biased, and they did have this star attorney draft their appeal, and he's now left Kirkland. So I don't even know if he's representing 3M anymore, Paul Clement. But we'll see what happens. Does that answer your question?
That does. That's excellent analysis. And yes, you are biased, but yeah, you are an attorney. And as an attorney, you're basically trained, and it's in your DNA to look at both sides, because you've got to advise your clients. Hey, listen, we've got a losing argument, so notwithstanding your bias, your ability to analyze this stuff is at a level that, makes you who you are, and an attorney, and an excellent attorney. And that's why you're here. All right, last topic, and then I'm going to let you go surfing the waves of Pensacola and all that. All right, so we have Aearo. Aearo is the one that designs the earplugs. 2008, 3M buys Aearo. Okay, all their assets, all their liabilities. And this obviously is one of their bigger liabilities. They didn't realize it at the time, obviously, but that's just the way of the world. All right, so now Aearo files the bankruptcy, and they try to do a quickie and say, oh yeah, this is going to stop everything, including the 3M, but 3M doesn't have to file for bankruptcy. All right, now what I understood is that when Aearo filed its bankruptcy petition, 3M actually created somewhat of a trust fund to fund the payments. They weren't just trying to get out altogether, even Aearo. They had put $1 billion in, and I think they made an announcement that there would be more money that that they'd be willing to cough up for this fund or whatever. So now that this ruling has taken place, do you have any idea what happens to this $1 billion? Okay,
Here's the thing with the $1 billion. It's a red herring. You can pretty much ignore the $1 billion. Here's what happened. So this was all planned at 3M. okay, we're going to have Aearo declare Chapter 11 bankruptcy. They entered into a funding and indemnification agreement with Aearo in order for Aearo to file bankruptcy. So there was a contract between Aearo, the subsidiary, and 3M Company. Under the terms of this contract, Aearo agreed to agreed to indemnify 3M against all liability related to the Combat Arms Earplug litigation. So we're talking potentially hundreds of billions of dollars in liability. Aearo said, you know what? We'll indemnify you for that. We'll pay for that. Okay, then the question becomes, how are they going to pay for that? They're a small subsidiary. So that's where the funding part comes in. 3M, under this contract, agreed to reimburse Aearo for any amounts that it ended up paying to 3M in order to indemnify it against these claims. Does that sound circular to you? So Aearo agrees to indemnify, 3M agrees to reimburse Aearo for the indemnification costs. And that includes attorney's fees, it includes everything. So it was a circular agreement. Now, as part of that circular agreement, 3M, they wanted to come out with a nice press release and say, look, we're putting $1 billion into this trust and it's for the veterans and we care so much about the veterans and we want to give them $1 billion. Just take this, right? And so, but under the terms of the funding agreement, the amount that 3M is potentially on the hook for reimbursing is unlimited. It's uncapped. So this $1 billion, I think we all know that $1 billion is not going to cut it in this litigation. And under the terms of their contract with Aearo, 3M is still, they agreed, it's an uncapped, it could be 10 billion, it could be more, like, we're not going to say, but, I think that they kind of wave that 1 billion out there as kind of something for the media to pick up on and be like, look, we're a good company. We're just, here's $1 billion, but you can kind of ignore the $1 billion. It's not really relevant. And it was kind of a ploy, but the point is, even under the terms of this uncapped agreement, this funding agreement, 3M is going to be on the hook for the entire, whatever, if the case ends up settling for 10 billion or more, 3M is going to be liable to pay that.
All right. So listen, it's a lot of information. It's not the end of the ball game, but the ruling essentially is a good ruling, an excellent ruling for the plaintiffs, for the veterans. Otherwise, if the decision went the other way, all the other litigation would stop. There'd be no trials. There's no pressure. They just sit back and, proclaim that, here's $100. You can't hear.
Delay, right?
Yeah. So listen, for all the audience here that wants, just give me one final answer. What's going to happen? This is what I think. I think that this is all posturing by 3M. This is their settlement tactics. Instead of lowballing and saying, okay, we're offering $5,000 to every vet to go, to go away and sorry you can't hear and thanks for your service. I think that this is just even more aggressive posturing than lowballing. And I think that at the end of the day, guess what? 3M, they, through these proceedings, have completely insulted Judge Rogers. They didn't just make legal arguments and say Judge Rogers was grossly wrong. They actually insulted her. And now guess what? All these cases are coming back to her. So good luck, 3M. Good luck is what I have to say. All right, Matt Hosen from Quinn Emmanuel, Associate, Mass Torts, Complex, Commercial Litigation, Antitrust. I tried to get him on to do a show about the live golf thing, but he shook his head to me about.
If you saw my handicap, you would not be asking me to talk about golf. It wouldn't make any sense.
All right. Well, listen, you're going to have to pay attention more from Cut to the Chase because I'm going to be featuring Matt, Mike Burns, and others to keep us all informed. It's going to be, we got to keep fighting for compensation, yes. Unfortunately. But I got a good feeling at the end of the day that the compensation is going to be there and it's going to be close to adequate.
I think so too. And the last point I would just add is 3M really thought they were going to win this injunction. They thought they had the law on their side. They thought they would kind of be able to do what some of these other large companies have done to get out of mass tort litigation. And they've done it. These other companies did it successfully, not in this jurisdiction though, and not with this judge. This judge, Judge Graham, is a very good judge. He saw right through their arguments and looked at the substance and the merits, and he put out this great order yesterday, 30-page order that we are very confident will stand up on appeal. And so it was just a very huge victory for us and the veterans.
Okay, so last point, if you're a veteran and you're suffering hearing loss and you're not involved in the litigation, you're like, is it too late? Bankruptcy, oh my God, I missed the boat. There's no boat going out. No, you can still get involved in this litigation. You can call Matt Hosen and he will tell you what to do. He will evaluate your case, tell you if you should join the case. Maybe it's your husband or your wife and they're too shy, they don't even understand it. Whatever it is, give him a call, free consult, and he'll set you straight. Anyway, Matt, surf is up. All right.
All right.
From Cut to the Chase. Thanks for coming on, and we'll speak soon again. All right.
Thanks for having me, Greg.
All right. Take care, everybody.